Hello and happy Monday. My name is Michael Leeserman here with the Trial Guide's Tip of the Day. It is May 20th, 2024. Today's tip comes from the video Direct Examination by William A. Barton, known to his friends as Bill Barton. And here is Bill Barton to read the tip. Hi, Bill.
Hey, good morning, Michael. And direct examination, I want to pause before I jump into this. And if you've crossed over from doing criminal defense or you're a prosecutor that crossed over, I predict that you never perfected the skills of direct examination. I can share with you of the 5 parts of a trial: jury selection, opening, direct, cross, and closing. If you put on a seminar, everybody loves jury selection because it's scary. Everybody loves cross because it's dramatic. Everybody loves closing because you get to put it together. And nobody hardly shows up on opening and direct. And if you're going to be an excellent plaintiff's lawyer, that is the one you must perfect. And it gets lost. So let's talk about direct examination. I'm going to give you a few key things. When you disclose your client's problem from the beginning, make the defenses go away. It's called preemption. And how you do that is your ABC. You're accurate, brief, and clear. And if you think about this like a trilogy, you have A as everything, the pre-liability, the plaintiff's condition, and then B is the liability event, and C is after, and dollars equals the difference between the way they are now, C, from the way they were before. A is caused by B. Simple enough. But there's a logic to it. And I want to tell you about preemption now. If you disclose your client's problems, a lot of times we have challenging clients. And I say that euphemistically and empathically. They may have a ton of problems, and they may even be unattractive plaintiffs, that often are, and had many pre-existing problems. You can own those. And I want to have a shout out to Keith Mitnick in his book, Don't Eat the Bruises, chapter 13, which is essentially owning their favorite facts, which is preemption. Chapter 14, in context versus out of context. And I think this is a state of the art and about as good as it gets. So I want to put a shout out for Keith. Now, what you do is, and I'm going to give you an example. Think of your client. And Mo Levine gave us this. He said, it isn't what you take from them, it's what you leave them with. So that's not exactly a quantitative subtraction from A to C. It's a qualitative assessment of where you leave them. And that's a reframing of the damages, and that comes under the as-is instruction. Now, there's a lot of big ideas back behind this, and I've just been very formulaic and given it to you. But this, and I'm going to give you an example. If I were to be picking a jury and I would ask them, now think about this. What is big to you and little to the world? People start thinking about it, looking down and to the right and up to the right. And they'll say, well, it means a lot to me to be able to hold my granddaughter. I have a garden. It isn't very big, but it's the most I can do with my back. Or I like going down on the beach and picking up agates after the storm. Why is that important to you? You think the world cares? Probably not. You've already framed the as is and embraced all the challenges within that. And it's a very seductive, powerful argument, and it preempts your closing and the court's instructions of as is. So when you disclose your client's problems from the beginning and you frame them properly, it can actually become incredibly powerful. What's big to you and little to the world. And there's your closing and your theme.
Yeah, that's great. I've heard it called inoculation. And what I love about it is not only does it deal with the facts because it's you facing the reality of your case, it builds to your credibility. I've got nothing to hide. I've got nothing to hide. Yeah.
Isn't that the truth? Yeah.
Yeah. Well, thank you so much for being here today and
Michael.
for sharing. Let's take a deep breath together and be aware of being alive, being grateful to be alive today. May we work today to reduce suffering in the world. May our efforts as lawyers and as people help to repair the world. May we fiercely and compassionately advocate for our clients and champion their stories this Monday. All right, I'm going to ring a bell 3 times now. This can take you into a meditation practice, a prayer practice, or just to remind you it's Monday. Go out, do good things, and have fun while you're doing it.